All right, if you're gearing up for law exams, you know judicial review and constitutional interpretation are, well, pretty huge topics. So in this explainer, we're going to break down the key concepts you absolutely need to get your head around to ace those papers.
Okay, so let's just jump right in with the big question, the one that really sits at the heart of everything else we're going to talk about. At the end of the day, who gets the final word on what the law is?
And that question brings us to our first major showdown, a classic exam topic, by the way, the fundamental difference between parliamentary sovereignty and constitutional supremacy.
So, on one side, you have parliamentary sovereignty. Here, Parliament's word is law, period. The courts can figure out what a law means, but they can't strike it down. But on the other side, you have constitutional supremacy, where the Constitution itself is the top dog. It sits above Parliament, and the courts, well, they get to be the referee.
So how exactly do courts play referee? This is where a really critical distinction comes into play, one that you absolutely have to get right in an exam. We need to split judicial review into two very different types.
First up, there's administrative review. Now think of this as a check on how the government uses its power. The court isn't looking at the law itself, but at a specific decision made under that law, like in the Zester license plate case, to see if the government acted properly.
And the classic benchmark for this, a name you really need to remember, is the Wensbury unreasonableness test. It asks, was a decision so completely off the wall, so illogical, that no sensible person could have possibly made it?
But then you have the second type, constitutional review, and this is a whole different ballgame. It's way more powerful because it's not about checking a single decision, it's about putting the law itself on trial.
And the Liang case is just a perfect example of this in action. Honestly, if you're writing an essay, this is a fantastic case to use because it shows the immense power of constitutional review. The court didn't just question a decision, it actually struck down a part of a law and, in doing so, changed it for everyone. That's a huge deal.
Now, this awesome power of constitutional review isn't handled the same way everywhere. So let's look at the two major models you see around the world. And yep, this is another great compare and contrast topic for your exams.
This table right here, this is basically your revision cheat sheet. In the American model, which is used in places like Hong Kong, any court can look at a law's constitutionality, but only when it comes up in a real, live case. The Kelson model, on the other hand, sets up a special, dedicated court just for constitutional issues. Knowing which model a country uses is key to understanding its legal system.
Okay, so let's say a court has the power to review laws. That immediately opens up another gigantic question. How on earth should they interpret the words of a constitution that might have been written centuries ago?
And this leads us to maybe the ultimate philosophical duel in constitutional law. On one side, you have originalism, the idea that the Constitution's meaning is frozen in time. On the other, you have the living tree doctrine, which sees the Constitution as something that can grow and adapt with society.
The famous Persons case from Canada is a perfect illustration. Initially, the court took a very originalist approach. They looked at the text from 1867, saw the pronoun he, and concluded that, nope, persons who could be senators could only be men.
But then, on appeal, everything changed. Lord Sankey came out with his incredible, now famous idea of the living tree. He argued that a constitution has to be interpreted generously to meet the needs of a changing world. It was a truly landmark moment.
So here's the crucial takeaway. This power, the power of unelected judges to strike down laws made by an elected government, it's never just a dry legal exercise. It is always, always controversial and deeply political.
And you really don't have to look far to see just how political it can get. I mean, just look at the recent U.S. Supreme Court decision to overturn Roe v. Wade. It was a legal earthquake that reversed decades of established law overnight. The reaction was immediate and intense. You had critics arguing that the court was ripping away fundamental freedoms and just bowing to political pressure.
But at the very same time, supporters celebrated it as a massive moral and constitutional victory, a return to what they saw as the document's original meaning.
And it's not just an American thing. We saw a very similar dynamic play out in the UK during the whole Brexit saga, when the court stepped in and ruled that Parliament had to have a say in the process. And what happened? Well, you immediately heard accusations that the judges were enemies of the people, that these unelected elites were trying to stand in the way of democracy and block the will of the people. So, with all that as background, where does Hong Kong's Court of Final Appeal stand on this? Well, it has made its choice very, very clear. It has firmly adopted the living tree doctrine.
I mean,
As far back as 1999, in the landmark case of N. Ka Ling, the court stated in no uncertain terms that the Basic Law is a living instrument, not some static historical document. So how does the court actually make this living tree idea work? It uses something called a purposive approach. And this slide right here is your roadmap. Seriously, this is the exact analytical framework you should be using in an exam when you're faced with a basic law problem. You start with the purpose, and you interpret generously to meet today's needs.
Which brings us to our final thought, and it's basically an essay question for you to chew on for your own revision. After everything we've looked at, which of these two theories, originalism or the living tree, do you think is a better fit for Hong Kong?